Pero eso fue lo que dijo.
Sí.
Cheers. Eso fue lo que entonces, eso fue lo que pasó. Y lo que más me molestó de él fue quien haya llegado primero de
No, yo digo para que aprovechen y escuchen mejor a Bajani.
Okay. So let's start. I would request you guys to please come as forward as possible because I won't be speaking very loud today. So.
Sí, sobre todo si se pueden, sorry Rita, si se pueden ir al frente porque no puede hablar Rita, está enferma. Entonces no va a forzar la voz. Entonces por favor.
Por eso
¿Ya hay hecho de apartado aquí?
Sí, porque así tenemos nuestros lugares establecidos.
Ah, ok. Entonces, some students are coming over.
Yeah.
And they will see in the front.
They are running.
Ah, yeah, there you
Okay, guys, let's settle down. We have to get started. Okay. Very good evening, everyone. This lecture is going to be a continuation on where we finished last time, which is on the topic of dispute settlement, worker organizations, dispute settlement mechanism. We looked at the aims and the purpose and the functions of dispute settlement mechanism under the worker organization, right? But before we start, I want to ask you a couple of questions. Can someone remind everyone else as to what we discussed last time? What did we do in the last lecture? Yeah?
First of all, we check the evolution or how this process evolved since the plan was established until we reached the WTO organization. We checked it was really important was the way the Congress and the members of this organization have an opportunity to negotiate first of all in the first stage that is called the
Consultation.
Stage, and is the main objective of this program
Of the system, yeah, or of this mechanism of dispute settlement. Perfect, excellent. And what do you think is the aim of this mechanism? Why was it needed, or why is it so important?
To solve disputes,
What kind of disputes?
trade disputes. I mean, if a country has
Any trade disputes? Between anyone?
between countries that are members of the WTO,
What kind of disputes? Any kind of disputes?
no trade disputes.
Any kind of trade disputes?
International.
Any kind of international trade disputes?
The ones that are contained in the main objectives of the WTO and the main agreements of it,
What are the main agreements?
or there are too many, right?
Right. So would the DSU apply on all those agreements or only the main agreements?
No, all of them, unless that that was not in. That was policy trades.
Trade policy review mechanism. So, dispute settlement of World Trade Organization has been established to resolve international trade disputes between member states, between the countries which are members of World Trade Organization, but those disputes should be arising out of the covered agreements, the covered WTO agreements. And which are the covered agreements? All the multilateral ones except trade policy. Right? So that should be your answer when someone asks you what DSU is and why do we need it? Why is it important? Yeah? Another question. If a matter comes up to a panel, or if a panel is asked to resolve a WTO dispute, which law is the panel allowed to apply? Is it allowed to apply any public international law or any multilateral or bilateral law? If there are two countries who are members of bilateral or plurilateral, if there are two countries who are members of NAFTA, but they are also members of World Trade Organization, they enter into a dispute, they go to panel and they ask the panel to solve the dispute. Which law would the panel be applying?
Can the panel apply a law? I mean, it's not like, first of all, they check all the facts and all this kind of
Certainly.
things. I don't know. I don't know.
Exactly. The panel has several functions. They check all the facts, they identify and examine all the facts, they identify the applicable law, and then they apply that applicable law to the facts of the case. So what law are they allowed to apply in resolving WTO litigations? Can they apply NAFTA?
Well, no, because they are under this special.
So they are only allowed to apply the laws which arise from the covered World Trade Organization agreements. Covered agreements are all multilateral agreements minus trade policy review mechanism. Right?
Can you repeat that one, please? Which is the exception?
All multilateral agreements minus trade policy review mechanism. And now, most of the plurilateral agreements have also been included under the purview of dispute settlement. Right? There are only one or two exceptions now. But without that, most of the multilateral and plurilateral agreements are subject of DSU. And if you read these agreements, for example, if you read SPS, if you read the agreement on agriculture, agreement on anti-subsidies, anti-dumping, you will find that they have clauses which incorporate Article 22 and 23 of GATT 1994 and the DSU agreement. So they don't have their own DSU provisions and their own DSU procedures and rules. They incorporate the rules and procedures given in DSU agreement into their own agreements. That is how they work, and that is how all these agreements are related. Do you understand this? Sure? Any questions? Okay. And now, this is what we are going to do in the lecture today. I first explain you in an illustrative way what the main steps of dispute settlement are. So what is the life cycle of a WTO litigation or a WTO dispute? Where does it start from? How does it proceed ahead? And where does it end? Right? How are WTO disputes handled by way of this system? So I'm going to explain that to you very quickly. I'll give you an overview. And then I'm going to explain you each and every procedural stage with the help of the provisions and the articles of DSU agreement. Because it is very important for you as WTO lawyers to be able to understand and interpret all the articles of the DSU agreement. Right? So we'll do that once we understand the whole process. Okay? The WTO dispute settlement process. You can briefly, roughly say that there are three main phases of WTO litigation, right? The first stage is pre-litigation. The second stage is litigation, or the stage of adjudication. And the third stage is post-litigation. So let's try and understand, otherwise it's very confusing. If I give you a chart and if I explain you all the steps, you'll be lost. So let's try and understand the system with the help of these three phases. Yeah? There are multiple stages, multiple rules, but let's try and simplify them. So basically, where does it all start from? Two countries realize that they have a disagreement. One of the countries, say for instance Mexico, who imports a load of shrimp to US, they realize that US has imposed a duty which is over and above the commitment which US agreed in the WTO agreement on the import of shrimps coming from Mexico, on the ground that Mexico is not fishing the shrimps in a very hygienic manner or storing the shrimps in the container in a very unhygienic manner. So on that ground, they have imposed duties, additional duties on the import of shrimps from Mexico, right? So let's see if, let's think that as a hypothetical case. And Mexico has objection with this policy for sure, because now that the duties have been imposed, the price of Mexican shrimps in US market have gone high, and their overall competitive advantage has gone down, right? Because the shrimps from Thailand and China have now become cheaper than the shrimps from Mexico, because Mexican shrimps have additional duties imposed on their price, imposed on their market value. So the market value has gone high. So Mexican authority now wants to raise this dispute with the US at the World Trade Organization. So the first stage would be that Mexican authorities or the Mexican Ministry of External Affairs or Commerce and Trade would informally try to approach the counterparts in US, the Department of Commerce in US. And they would say, hey, what's going on? Why are you doing this? You know, our traders are bearing, we faced losses up to the value of $100,000 in the past 2 years. So our traders are losing a lot. We have to do something about it. And they don't receive any response. After trying this friendly talk, the next stage would be, so they start with a very informal talk. If they don't receive any response, they go to the second stage, which is known as the stage of consultation. This is the first official stage, and this is where, so until this stage, you cannot call this dispute a WTO dispute. Until this stage, it remains a disagreement or a conflict. But after it crosses the stage of consultation, a conflict becomes a WTO dispute. Because at the stage of consultation, Mexico will issue a formal written notice to the US authorities that we want to come on a table with you and negotiate this with you. And if we are unable to negotiate this with you, we will file a case against you at the WTO court. Right? They only have 60 days to try and negotiate a solution. If by the end of these 60 days, no solution is reached between the two parties, do you want to ask something? Do you want to ask me something? That's quite annoying. Please try not to do that. Please. So, within 60 days, if no solution is reached, then they will enter the next stage, which is serving a formal notice on the other party that we want to take you to the court, to the World Trade Organization's court. So they will, at the third stage, serve the notice of intention to take United States to the court. And by the end of the stage, if nothing happens, if no resolution takes place between the two parties, then the dispute will go through the second phase, which is the phase phase of litigation. At the phase of litigation, the first stage would be where the dispute settlement body will create a panel of 3 judges. How will they create a panel of 3 judges? They usually have a list, as I told you last time in the last lecture. And the Secretariat of WTO proposes 3 names to the parties. In all conditions, they will accept the nominations. But if they have any serious objections, then it is the Director General of World Trade Organization who will resolve the matter and finally appoint the 3 judges, and their or his decision is final. Right? So this is how these 3 judges are appointed. So the panel is composed, and then the next stage is examination or investigation. What happens at this stage? It is basically the stage of trial, similar to a domestic litigation. Domestic litigation, what would happen at a stage of trial? The judge would call the both sides of the parties. They will hear the arguments of the 2 parties. They will meet them. They will try and understand what the case is and what the views are of the 2 parties. They will ask the parties to submit written briefs. They will ask the parties to supply evidence to support their legal claims and counterclaims. And exactly that's what happens here. At the stage of examination, 2 oral meetings or 2 oral hearings take place between the 3 judges and the 2 parties, the 2 countries. And both countries, the complaining country files its complaint, and the responding country is given the opportunity of filing its response. So both submit their written submissions to the judges, right, at this stage. And in the written submissions, they have their evidence, they have their legal claims, they have their memorandums and everything. And they get 2 meetings, 2 oral hearings at this stage to meet the panel and explain the case to the panel. Once examination has taken place and the judges feel that they have taken in all the relevant written submissions from the party and they have exhausted the 2 oral hearing opportunities they have had with the party, that will lead the process to the next stage. So the dispute would then enter into the 3rd stage, which is known as the interim review stage. At this stage, these 3 judges will issue a draft report to the 2 parties, and they will ask the parties to read the draft reports. So the parties will read the draft report. The draft report would normally have the factual finding as to what judges think about the facts of the case. So the report will tell the parties whether these 3 guys have understood where we are coming from or not, right? And it will also have their preliminary findings as to what is it that they're going to decide. And if the 2 parties want to comment or want to request the judges to reconsider their findings, they have to submit a request to the judges in writing. If they do not want that, then the interim review will enter the 4th stage, and the interim report will then become the final report. The final report is then issued at the 5th stage to the parties and the DSB, the dispute settlement body. And normally, a panel has to submit the report within 9 months from the date on which the panel was composed. So from this date until this date, they only have 9 months to go through all these stages. In practice, does that happen? Not really. Yeah.
I even heard about the number 5 is DSU.
So the final report is then issued to the 2 parties and then subsequently to the dispute settlement body. Right? Why is the report issued to the dispute settlement body? What would dispute settlement body do with the report?
They're gonna vote in so as to see if everybody agrees, and they're gonna be mandatory.
How are they going to adopt them? By what process?
And they're gonna be negative, well, if there's, everybody has to have a negative vote so as to join to pass?
Exactly. So the negative or the reverse consensus. The purpose of sending report to dispute settlement body DSB is for the purpose of adoption, because until here it is not a report or it is not a ruling, it is a recommendation and it's not binding on the parties. But before that happens, before DSB is asked to adopt the report, these parties are given an option to file an appeal. To file an appeal against the ruling, against the recommendation. So if one of the parties, most probably the one who has lost the case, wants to appeal the decision of the panel, they will file an appeal, and then still the litigation stage, the dispute will enter its next phase, which is known as appellate review. I have a wonderful handwriting, no? I'm the worst handwriting in the world. So,
don't worry, my writing is work.
Really? I'll be happy if I read this.
They haven't complained about it, but it's terrible.
So the dispute will enter the next phase, guys, which is known as the appellate review stage. At this stage, what will happen? The dispute settlement body will compose a panel of 3 judges again from the appellate body, and those 3 judges would act as like the Supreme Court of Mexico, you know, the final appellate apex court, which will take the final decision, right? So the appellate body here would review 2 things. One, whether the panel has applied the right law, and second, whether the panel has interpreted that law in the right manner. 2 things, application of law and interpretation of law. They are not allowed to look into the matters of facts. They can only review and modify and reverse the ruling on the basis of issues of law. Okay? And the second one is interpretation. Once they give a report at the 7th stage, appellate body passes a report. That goes to the dispute settlement body, and that is binding. There is no second right of appeal. There is only one right of appeal to the parties under DSU agreement. So once that's done, it goes to the DSB, and DSB adopts the appellate body's report and the panel's report as changed or reversed by the appellate body. And once the report is adopted by this DSB, by the dispute settlement body, it becomes a ruling. And from that stage, it becomes binding on the parties, because the recommendation now becomes the ruling. And once you have a report, you have a ruling which is binding on the 2 parties, the dispute would normally, in its natural course, enter the 3rd phase of its life, which is the post-litigation. At the stage of post-litigation, whenever a ruling is adopted by dispute settlement body and becomes binding, the very first step is that DSB will ask the party which has lost the case to supply in writing a proposal of implementation. So the losing party, if say for instance US has lost this shrimp case against Mexico, which we filed against US at that stage will be asked to supply a written document which will say how they will withdraw the measure against which Mexico made a complaint and when they would do that. So they have to give exact dates and the extent to which they will modify their policy and how they will do it. So they have to give their implementation plan, right? And that stage is known as the stage of implementation proposal. they have to give this implementation proposal within a reasonable period of time. What is reasonable period of time? I explained it to you in the last lecture. You should know. There are 3 ways of calculating reasonable period of time. I'm not going to say that again, unless one of you help me with that. How is the reasonable period of time calculated?
It depends on the countries if they don't agree. No.
Anyone else?
Yeah, I guess that as she said, first of all, the parties come together and they try to set a reasonable time. But if in the case that they can't agree or they can't well, the BSSG is the one that is going to make a proposal about the time.
Not really. There are 3 ways. There are 3 ways in which reasonable period of time is determined. The first option is that the party which has lost the case would propose a time, and that time should be approved by the DSB. If it is not approved by the DSB, then the second option is that both parties, the offended and the offender, have to come together and agree to a time. If they cannot agree to a reasonable time of implementation, then comes the third option, which is that DSB appoints an arbitration panel. And it is that arbitration panel which decides the reasonable period of time. Approximately it's 15 months when it is decided by the arbitration panel. Approximately. But these are the 3 options as to how reasonable period of time is calculated. It is a very important catch, and it is an important question for your exam. So important to understand these 3 options. Yes.
Sorry, and this panel, the one that is going to set the reasonable time, is different from the one that was in the litigation part.
Can you repeat your question, please?
Yeah, that if this new panel that is going to set the time,
Yes.
it's the same that it's the same panel that the one that was used in the litigation part.
Okay, very good question. So basically, there are 2 kinds of arbitration panels which are usually appointed, right? One is appointed at this stage, when a reasonable period of time has to be decided as to when the implementation will take place by the offender party, right? For that, there is no requirement of appointing the original judges as the arbitration judges. For the second arbitration, which we will talk later, which has to decide the level of retaliation or the level of suspension of concessions as a form of remedy in cases of non-compliance, then original panel has to take the position of the arbitration panel. And there is a difference between the 2. We'll come to it in a second, yes.
Is it possible to appeal the plan?
Appeal the plan?
In
No.
case the panel...
So as I said, if the plan is not accepted by the other party, then an arbitration panel will be appointed by the
Yes, in
DSB.
that case...
The arbitration panel will decide, and that decision will be the final. It's not possible to
Okay.
It's not possible, right? So at this stage, US will give a plan of implementation. US will tell DSB how it's planning to withdraw its measure against the imports of shrimps from Mexico, right? Within a reasonable period of time. Say for instance, it says, I am going to withdraw this measure or additional duties which are imposed on the shrimps coming from Mexico within 15 months, right? What happens at the end of those 15 months? Is the other stage of post-abrogation. The other stage is surveillance. And this is done by the dispute settlement body. Surveillance of the implementation of the award. So the dispute settlement body at the end of the 15 months would see whether US has implemented the award. But before they see it, Mexican authorities will be wide awake and they will see if the report is not implemented, then before DSB does its own study, the Mexican authority will go to DSB and tell them, well, the 15 months, the reasonable period of time has finished, it has expired, and they have not withdrawn their policy. What do we do now? Can you authorize us retaliation? Yeah? So at this stage, at the end, in case they comply, the dispute finishes here at this level, at the stage of settlements. Is finished. In case of no compliance by US, the dispute will go ahead to the next stage, which is known as the non-compliance stage. Now, what will happen at the stage of non-compliance? How do you think, any guesses, how do you think Mexico will be able to enforce the award which it has won at the WTO court? What is the remedy?
By imposing some tariff, maybe.
Okay, what else?
I don't know, I just have that in mind. Or retaliation can be imposing some tariff.
Okay. So basically, in cases of non-compliance, this is very important to understand. If Mexico complains to the DSB that US has failed to comply with your order, with your ruling, then DSB will have one option, which is that they will appoint a panel of arbitration. And that panel of arbitration would compose the original judges who decided the case as the panel, as the original panel, right? Because they know what the exact matter is, what the exact legal problem was, and what would amount to full implementation of the order, right? So they are appointed as the arbitration panel here, and they are asked to decide what should be the right course of action. But before a panel of arbitration is appointed, there is one option available with the two parties. So, in case of non-compliance, well, the first option is full compliance. DSB says to US, you have to comply fully with the award. So the first preference is full compliance, and that is the permanent ultimate remedy. There are three kinds of remedies under dispute settlement. There are three ways of enforcing award and your WTO right in cases of non-compliance. Three remedies. Out of these three remedies, one is ultimate and two are provisional, temporary, right? So the ultimate or the permanent one is full compliance. That is the most preferred remedy. That US should fully comply with it. If they don't do that, then the second remedy is compensation. So Mexico will say, okay, if you can't withdraw your measure or your extra or additional duties on the import of shrimps from Mexico, then you give us some financial compensation to compensate the loss which our farmers, fishermen and exporters are incurring or are going to incur from today to the date on which you will withdraw your policy. Very important point. This remedy, the remedy of compensation, is not retrospective. It's prospective. So, the parties or Mexico cannot ask US to compensate your exporters and fishermen from 2001. If you filed the case in 2001 and the ruling was given in 2004 and now we are in 2005, you can't seek damages from 2001 to 2010 or 5 because the remedy of financial compensation is prospective in nature. So if you do agree with US on any amount of compensation, it will be from the date on which you arrive at an agreement until the date which US says, okay, at this date we will withdraw the duties. So until that date, we will give you some kind of financial compensation. That is what your second remedy is. I don't know what you think about it. To me, I think it's a very ineffective remedy. Because first of all, US would not agree to give any financial compensation. right? Because the WTO law nowhere says that DSB can compel a party to give financial compensation. It's nowhere said in the law, unfortunately.
It should be retroactive at least.
Yeah. And this is one of the main arguments by many WTO law professors, no? For a few years, they were like, all these articles were written about how to enforce and how to strengthen the remedies of dispute settlement system.
Actually, I'm receiving one paper in French.
Okay.
So
Perfect.
we'll see what's the point in that paper.
Exactly. That's wonderful. So this is what the main problem is. But this is a fact. But in all probabilities, and let me tell you, practically in most of the cases, in 99.9% of the cases, the offenders who have refused to comply with the ruling have never agreed on a compensation. They have never agreed to give financial compensation to the party who has won the case. Never. It has never happened. So this is one remedy which has no practical value. That leaves us with the third option. Retaliation. We launch a war, an attack against them. Not a war literally, but a war of trade. If Mexico opts for retaliation, if none of these remedies are able to help Mexico, then Mexico will have to go back to DSB and ask DSB to appoint a panel of arbitration, which would normally be the original judges who have decided the matter as a panel. And those judges have two things to do during the arbitration. Two things. They will first decide whether to authorize you to retaliate. Is this serious enough a matter to authorize you to breach the rules of WTO law against US and indulge in discriminatory trade against US? And second, if they want to authorize you to retaliate against US, to what extent? And they are only allowed to authorize you to retaliate to the extent of your damages. And your damages should be equal to your nullification or impairment of interest or benefits under the trade. So say for instance, if Mexico during these years, due to these additional duties which US has imposed on your shrimps, if you or your economy as a whole has lost 100,000 USD in the last 5 years, then you would only be authorized to retaliate to the value of 100,000 USD and no more than that. That's what I mean when I say that they will first see whether they want you to retaliate and to what extent. And this extent has to be equal to the amount which you have lost in the entire period as a whole because of the measure against which you filed a challenge. You understand this?
But what happens if the loss continues?
Exactly. So if the loss continues, then arbitration panel would calculate a reasonable period of time in which they think US will withdraw the remedies. So if the arbitration panel thinks, by calculating a reasonable period of time, that say for instance we are sitting in 2005 and they feel that by 2010 they would have satisfied the aims which they are trying to achieve from this measure, and US will be compelled to withdraw the measures against which are under question today, then they will allow you to retaliate to the value of losses which you have incurred from 2001 when they imposed the measure up to the value of 2010, up to the value of reasonable period of time for the withdrawal. Do you understand this remedy? Sure? So this is, and how does it work? Can you give me an example? Yeah.
I don't understand the extent figure.
The extent figure? Okay, can someone explain that for me, please? So To what extent would Mexico be allowed to retaliate against US if US does not comply in this case, in this hypothetical situation?
Calculated loans that the country demands, that should be the extent.
Okay. They calculate the overall value of nullification or impairment of your trade benefits. And they allow you to, or they authorize you to retaliate against US to the extent or to the value of that amount which you have lost. Right? And in that manner, you can to some extent say that this remedy is retrospective as well as prospective. Don't you think so? But there is a big problem with retaliation. Okay, Mexico is a powerful country. I won't dare say a word against it. But think about the case where Cuba has filed a dispute against US. It's a small country. Do you think it would have the capacity or the trade traction or the trade power to retaliate against a country like US, even if it wins a case in the WTO court? No. So what is the point of these small countries going to the WTO to enforce a decision against big giants like US, like EU, like Canada, like Japan? Because ultimately, even if they win a case, they can't enforce it. They don't have retaliation as an option because you need to have retaliatory power. How can you retaliate? You can ban the import of Louis Vuitton bags, or you can ban the supply of McDonald's food products from US into Mexico, or you can impose discriminatory duties on the import of various products, various clothing brands from US. And then what will happen if you do that in Mexico? Your customers would suffer for sure because you guys would not have a choice of wearing all the US American brands which you have now. But at the same time, the American merchants there in America would also suffer because their profits and their sales would go down. Because now you guys as the customers, they have lost you as the customers. So then they will go to the US Department of Commerce and say, hey, what's wrong? They have retaliated against us and our sales are going down, our economy is, bearing the brunt. You have to do something. And then they'll say, okay, now Mexico has started retaliating against us. We need to think about withdrawing the measure so that they withdraw their retaliatory measures against us. But this option would not be available to a small country who doesn't consume, or a country where there's no McDonald's, where there are no US merchant brands, where there's no H&M, where there's no Gap. The option is not available to that country. It's as simple as that. They don't have retaliatory power. And therefore, even the third remedy is very weak. Don't you think so? So that takes us to the very end of the dispute. If nothing happens at the stage of retaliation, normally developing and least developed countries give up by this stage. They don't even try retaliation because that would not do any good to them or their economy, but that would jeopardize their relationship with US, with as important a trade partner as US. So normally most of them would die by this stage. But if they do survive, it's a very difficult remedy to enforce. So you see, the process is there, the time frame is there, procedures and rules and laws are there, but the enforcement mechanism is weak. That is my own personal view. But you may have other articles out there which say a different story. And those articles and those arguments in those articles are equally valid. Because they argue, and some of the authors argue, still, WTO's court is one of the most powerful courts in the world. Look at the sanctions which UN has. Look at the sanctions which International Court of Justice has. Our sanctions and our enforcement mechanisms are still way too powerful, way too strong than their sanctions or their ways of enforcement. And that is a reality, that is true. Because ultimately this is public international law, this is not national law. And there has to be balance between the integrity of the country and the protection of public international rights. I leave you with these two perspectives to think about, right? I was planning to cover...
Just one comment.
Yeah.
I think that you're actually talking about a very interesting subject, because really we are in a very thin line between international public law and international economic law, and the way you try to compel states to accomplish all the sentences or the judgments of the legal procedure in the WTO. And really, I think you have material to make a whole paper about this.
From both sides of the argument.
Because you can have a very restricted opinion or interpretation about how states have to compel and have to obey these judgments, and on the other hand, you can say, well, we're talking about states. We're not talking about parties in a civil case.
We were talking about domestic litigation, where you have your sanctions, where you can put a person behind the bar if that person does any contempt of the court. At the WTO's court, you can't do that. You can't put the ambassador of US behind the bars in the international prison just because they don't comply with the order which you have won. You can't, because those sanctions are simply not there. That is the handicap of public international law, and we all have to agree to that. But there are ways of looking at it, and both ways are valid. So I encourage you to read these papers from these two different perspectives. I'll send you the links, and you must read them to understand the enforceability and effectiveness of these three remedies which we have as a way to protect. Because we all talk about WTO rights, but what are WTO rights? How are you going to protect them? Through these mechanisms? Yes and no. Do you have the capacity to protect it through these mechanisms? Yes and no. But not many countries have. Not even many emerging countries. Right? So, now I take you to the final slide. I was planning to go through the most important provisions with you to explain you what the interpretation of those provisions is. You can see in the slides, I've given you all the main articles of the SEO. So I thought we'd have the time to go through that, but as always, I was over-ambitious. We won't have the time to go through that, because for the next 10 minutes, I want you to discuss these three questions, which I have for you on the last slide. I don't want you to do any group activity. I would randomly ask these questions from any one of you, and I would expect a response, because I have discussed enough on these. And at the end of this exercise, we both have a surprise test for you. Okay. So, let's get started. Who would want to take up the first question? Which I think is a simpler one. Yes, please.
What are the limitations of these remedies?
Yeah.
Well, as you already told us, it is about the power different countries they have in this dispute settlement body or mechanism. I think that's one of the main points of this point.
What kind of power? Can you explain that to me with an example?
For example, with weak countries, if I can say that, against.
How would you define a weak country?
Well, non-developed or less developed country, maybe.
Okay, so why would it be weak and why would it not have the power to retaliate?
Of course, it is like not protected. I mean, it is not. That country has not the power enough to find a better way to solve the difficulty of the problem they are justifying.
And they do not perhaps do that level of exports and imports to the world, which would justify them to attack someone else by way of trade. Because even if they ban imports from US, say for instance if Cuba bans imports of US garments from US, is it going to make any difference to US? No! But if Mexico does that, it's going to make a hell of a difference to US. So that's what I mean by retaliation power.
It would work if economic have the same powers between the countries that are in dispute.
Yeah, or similar powers to some extent. Yeah. What do you think about compensation as remedy?
Compensation.
Yeah. Do you think it's more effective than retaliation? Or more positive than retaliation?
Maybe positive, maybe a compensation. It involves maybe I'm misunderstanding. If I am doing, just let me know. That's it. A compensation has to do with tariff, that is established for the country. So it stops a little bit that the damage of the part that is doing. Maybe it could be kind of positive or a little bit different than retaliation. I don't know. In which way? I have to explain it. I don't have more words for that, but I think
I find it really unfair, right? Because it's only for perspective and not for all the damage caused. So it's unfair and it's a little bit unreal because no state's gonna pay, as you said, nevertheless. So I don't think that's gonna work.
And think about it, if a country is not going to comply with the ruling, it's not going to pay you compensation.
No, yeah, if they don't want to comply,
So
they're not gonna complain.
it's a remedy which is not practically applicable. And it has never been resorted to. No country which has lost a matter at WTO has ever monetarily compensated the winner in history, no?
Yeah, no.
Correct me if I'm wrong, but I don't remember a single case in which it happened. So it's an impractical remedy. It's a remedy which is of no application at all. It has never been applied. Okay, thank you. What about question 2? Who would want to take up this question? Do you think to provide an adequate incentive to comply with the agreements? And are you a mechanism for states to resolve their rights?
I think states may find the remedies a little bit weak, but what about the political facts? I mean, I don't know in WTO, but in WCO, for being a chair of a working group, you're gonna be like loved by all the countries, so you're gonna be like popular and to act and to perform like good practices and all that. What about in here? That may act in favor of the other state, no?
Very good point. Very good point. Excellent. And this is one of the main, incentives. The incentive is not to have to be or to look very obedient. The incentive is to have an image of international comedy in the international fraternity. To have an image with your colleagues, with your partners, that you obey the regulations. Because if you have a body image, which countries like US has, then other countries would hesitate to do trade with them. Because they would think that if anything goes wrong, they're not going to listen to us. They're not going to even listen to the WTO code, even if we win the case. Think about it in that manner. And what about the final question? What other remedies ought to be considered? So do we have a genius in the class who can suggest a remedy which is, in your opinion, more effective than the 3 remedies we already have? Can I have this answer from you, please?
You from me?
Yeah. No? You don't even want to give it a try?
Yeah, but I don't know.
Nothing at all? Any initial idea? Any preliminary idea?
I read something about the compensation, but
Yeah.
I'm not sure. I'm not sure that the thing that you told us says like I don't know how do you say suspender.
Suspension of concession.
Suspension of concession.
That is retaliation.
Okay.
Yeah.
Well, I don't know.
So do you agree with that remedy? Do you think suspension of concession is an effective remedy?
Well, I think it's better than compensation because compensation it's not working. It not works.
Okay. Do you want to say something?
Yeah, well, in my opinion, is maybe a little bit extremist, but maybe we can say that if you, like a country, you don't obey the final solution, that maybe all the countries have to stop to make commercial trade with them. Maybe that is hard. I don't know how to say that in English. is economic blow, something like this.
Well, think about it. Think about it. If Cuba wins a dispute against US and Cuba wants all other countries and all other WTO members to stop trading with US, would you as Mexico, you trade a lot with US by the way,
Yeah.
would you stop your trade and would you stop earning all the profit you're earning just because you want to help Cuba?
Yeah, you're
So let's talk about a more practical way of dealing with
I
this.
think that well, it could be a kind of retaliation, but not exactly about commerce. I would think I would do as a country to start.
We may have a paper on all this, from
How can I say?
all these opinions.
Very good
and
ideas, yeah.
one of them may come up with a very good suggestion.
Absolutely.
I would
Okay.
prohibit, or not prohibit, but put some barriers. For example, about rice. Like, you know, if I were in Cuba and I will stop or put some barriers to US citizens in order to travel to my country, or barriers to some enterprises in order to do investments in my country.
But you're
I
also
will-
affecting your own people, no? So,
Not really. It would be.
But that is always the impacting with retaliation. If you stop US imports of garments, if you stop H&M and Gap coming in here, some of us may be huge fans of American brands, you know, some of us may just be wearing Benetons and Gaps.
Not
So what
punishing, but
happens?
making them more difficult. If before I didn't ask for a visa to enter to my country to your citizens,
Yeah.
now I will ask for a visa, or I don't know, that kind of retaliation.
Yeah, but that would have one limitation. And that limitation would be,
Human rights.
how special is your country? How many people really want to visit your country?
Yes.
And that is, you know, I'm very glad that you brought up the solution, because Cuba recently did that. You know, because it won dispute against US, and US denied compliance. And now Cuba does not allow American citizens to enter. It is with great hassle if an American citizen wants to enter Cuba, wants to go there for holidays or something else. It's almost impossible for an American citizen to get a visa.
But
To that extent that you go to Cuba, or you can get it on arrival, or you can get it at the airport. So say for instance, if you want to book your tickets to Cuba for tomorrow, you go to the airport, you get a visa, you can purchase it for £10 or something at the airport, right? So, but when you do that, they ask for your passport, and they ask you to fill up a form that you are not an American citizen and you don't have your second passport as American. You know, because that's what Cuba has done. So I'm glad you brought this up. But again, this has a benefit and it has a
yeah,
limitation.
well, not exactly to banish, but to make it very difficult.
Exactly.
I will do it.
You will do it. Any other solution? Well done. That's a very good point. Any other solution? Any other way of enforcing the rulings of DSB against the one who has lost the case and denied the compliance, refused to comply?
I'm happy because some of these kind of solutions that I'm proposing, we already talked about it
Exactly.
in some lectures.
Exactly. And I'm
So,
glad they're coming
What
up.
happens in the real life?
Yeah. I mean, there are problems with those solutions, because that's precisely why, and many of these solutions, one of the solutions which you have just proposed was discussed with the Doha Development Round, which started in 2002. Nothing has been done so far because it's a very highly sensitive proposal, you know, and it's very difficult to ask all 160 members to agree to this kind of proposal. But these proposals have been going around the tables for many, many years, since 2002. But can you tell me one more possible, potential remedy, which, if given an option, you would establish into or incorporate into the DSU agreement? Yeah? What do you think? Anything? Anything crazy, anything vague?
Well, the
the only thing that I can think about it is like what has done the United States with some companies when the United States tries to reverse some kind of rule. I don't know, maybe in the financial market, I would ask, I don't know, like the New York, what's the name, like the, what's that, valores,
Stock option.
the stock house? No.
The stock exchange?
Stock
Yes.
yeah.
Yeah, like to stop some kind of assets.
Financial
Exactly,
transactions.
exactly, some kind of that.
This is what has happened between Russia, US and EU, no? Over the dispute of Ukraine.
Oh,
When
yeah.
Crimea was annexed to Russia,
Yeah, you're right. Yeah.
US and EU imposed many economic sanctions on Russia and they stopped many varieties of economic exchange with Russia. And likewise was the case with Russia. Russia did the same. Russia reciprocated. It retaliated. And now you have these economic sanctions going on. For the past 2 years, they've been extending the deadlines, but there's a solution. But that is certainly an option. You know, that's not allowed as of now under these rules, but that has been happening.
For example, in my job, we are an American company and we are forbidden
Yeah.
to make or to, well, we are an insurance company and we are forbidden to insure or pay any claim or anything
Yeah.
to Cuban citizens or Crimean citizens or Syrian citizens.
Yeah.
There is a list and there is also a way of retaliation.
Yeah, that's because you're US Americans. You can't blame that on sanctions. Okay, it's time for a surprise test. I would say that it's not a very easy one, but if you have paid any attention to what I've said today and on Tuesday, you can easily answer all 5 questions. Just 5 questions. Right? Don't try to jump over conclusions. Read them carefully. Read the problems and legal problems carefully. And then answer.
Les aconsejo, por favor, que consulten el entendimiento sobre solución del diferendo. Está en la página de leyes. Todo esto que dice ahorita
Si quieres la ver. Aquí tengo otra.
I just told them, Amrita, to look for the Spanish version of the
That's very important.
No está grabado.
And for the next week, especially for Thursday, you have to bring a printout of the DSU agreement. In English or Spanish, your choice. But you have to get an agreement with you. You can download it from the website of WTO. Now WTO should be your preamble, the website.
Está en español, ahí está. La versión en español. They can have Spanish or English version.
There are Spanish,
Or
French, and English versions available on the website. So download any, we don't care, but come with the agreement. Because you will be given a problem question, and you will be divided into teams in 2 countries. You'll be asked to apply, first of all, find the law, and then apply the law to the facts which we give you. And the winning team gets bonus points in that one question. We'll do the rest. Okay, it's time for you to do your answers now. You have 10 minutes. Carefully read all 5 questions and answer.
Ah, de esto. Sí.
Thank you so much. your eyes are okay. You have your eyes red or
I
something.
feel a bit of both, yeah, so that's why I know. That's fine, I know it.
I mean, if you want 5 to 10 minutes and we
Let them
will.
learn. I'm used to it. I told you. But here I still have options. If I cancel the class, then if I've had an operation or if I'm in the hospital, okay.
What's wrong with those English people?
Rules are rules, you know.
Oh, yeah.
The sun never sets on the kingdom, so you have to go by the rules. That's what the problem is. Guys, if you don't understand the question, please ask. Just raise your hand and I'll come to you and I'll explain you the question. Okay? I think the target has received
I'm working individually, yeah? No, it's not a teamwork.
exactly.
They already chose me for next semester.
Yeah? Awesome.
So I think we did a great job.
Wonderful.
At least. Till far. So we can when you come back from the
You know, I
weekend.
want to do it. I want to do it.
They need to have the understanding. Because otherwise, I mean, here it's going to be hard for them because they haven't read everything, I'm sure.
But you need to explain all these articles to them.
Right now.
No, not
Next.
right now.
The
Not
next.
next.
Very fast. Well, not for the next one. The next one is
Next
next
one is on
later.
cases. And then one after, we have a move.
No, what we're going to do is for next lecture, I'll explain just 3 or 4 cases. And then we'll do the contest.
Because after they are explaining cases, they will have no excuse to not be able to find the law or find the law because you will tell them the application of law to the process and how panels are done, how after the bodies are done. They will be able to do the same. So let's see. And you also need to work on the question.
You want to do the questions for the final exam, right?
Sí, son.
Yeah, we can do that. Yeah. We have to do it. We have exams of 2 days.
Yes, but the problem is that on the 26th, I had studied the defenses, the one that I chose.
Yeah.
And then we have
Yeah.
Oh, no, it's only one answer.
There's only one answer. There's only one answer.
Okay, now that's it. It's
Yeah.
only I was confused.
5 more minutes to go.
It's confusing.
That's for the challenges.
Yeah, I love
There's
challenges.
no point giving
Tiene una hoja de
us
lista, así que Gracias.
You're all master students. There's no point giving a simple question, no? You have to challenge your mind. Only then you can bring the best answer.
Este es el título del artículo.
The general principles of public international law. And one of the general principles is customary. I know it's tough, but do I have 3 more minutes to go? What did they,
Yeah.
next week? I tried to convert it in English, but it wasn't really clear. You said something about the wine and
Yeah.
what is that?
Normally, each year, what we do,
This is not a group activity, guys, or you get allowed to talk. Yeah,
every year
yeah,
we make like a Christmas dinner,
okay.
and everybody brings a bottle of wine.
This is Christmas dinner.
Yeah. No. We have a Christmas dinner in Itan,
Yeah, okay.
and it's all the people that works in Itan. We have a Christmas dinner, and they're gonna give you wine and stuff. But
But that probably would be after I.
only the package. And this is very, private
Yeah,
dinner.
yeah,
And the thing is that everybody comes with a bottle of wine
yeah.
that it won't pass 600 pesos. It cannot be expensive. Yeah, beyond 600 pesos.
Okay,
So everybody comes with a bottle,
yeah.
and we try each bottle of everyone. So
Okay.
you have, if we are 6, if we are 12, we have 12 glasses of wine.
Oh, wonderful. That sounds really, really good. Okay, are we good to finish the activity? Shall we have 1 more minute? You done?
Yeah, but I'm not sure.
That's fine. Even we were not sure if we had the
I
questions.
think I'm the last class, so I have fun with that. So, yeah.
Why were you not
Very
there?
bad.
Tienen que consultar el entendimiento, si no, están a ciegas. Me lo digo.
Sí, sí, sí.
It's very difficult to understand the topic if you have missed the first introductory lecture on what is this interface.
I will study this weekend.
I gave slides to your colleagues, so you can take the slides from them.
Yeah.
At least that way you know what all the things we covered and you can accordingly revise them
Yeah.
from the book.
Yeah.
Yes, so it has to be under 600 pesos, but then the limit is maximum 600 pesos.
And that's it. And that's it. Yeah, we all have to come with a bottle of wine and we are going to a restaurant for dinner.
For dinner, yeah. Sorry. Bueno.
Okay? All right, 1 more minute to go. I like the way you this order.
yeah.
That's not acceptable. You have to select one option.
But I
Otherwise,
said
I'll cancel the entire question.
this put this one. I put my this one. No? Okay.
You have to select one option. Otherwise, you get.
No, I select only one. But this is this one.
But you cancel that.
Okay.
This or this.
Cancel this one.
Are we good to finish?
this?
Yeah?
Do we have to put in our name?
Yes, please. Can you all please put your names on it because we need to mark your assignments. And you all will get grades, you all receive marks in the next lecture. So we need to have your names. Please do not give these sheets back without your names on the top of the first sheet. Okay. I think we've had 15 minutes to do this activity and that's sufficient. In 30 seconds, we all have to stop writing. 30 seconds and you all have to stop writing. Thank you.
Sí, amigo.
Just to be concentrated.
Can I have the presentation? Because I
Here, have this one. ¿Nadie faltó de asistencia?
Okay, we need to have the papers back now. We're almost short on time.
No debería de grabar esto, fíjate, ya estoy